What's up, family? Welcome to Business Law. I go by Lonnie B. Law, and we're going to deep dive into this great book, Business Law, The Legal, Ethical, and International Environment by Henry R. Cheeseman. If you have been studying to get remedy and come across Pastor Freedom and or Manson Mahatma 888, then you know they both recommend this book. I actually majored in business law over 20 years ago at Washington State University, and Henry R. Cheeseman wrote the very first business law book for the first class that I took. But over the past almost year, God has led me back on this journey. I have not really truly used my degree, so here we go. All right, this book is dense, it has a lot of information. I have not read through nearly half of it, so I'm doing this to help myself and to help those who are also reading it or perhaps have not been able to obtain their own copy. All right, so let's dive on in. I'm open to feedback. I don't know exactly where this journey is going to take us. I have some ideas of some other things that I would like to read with y'all or discuss, but we'll just see where the Spirit leads us, all right? So, again, we're going to be reading Business Law, The Legal, Ethical, and International Environment by Henry R. Cheeseman. I just realized that this book also has not only the Uniform Commercial Code in it, but also the Constitution, and it touches on the Bill of Exchange. So, just to let you all know that this information is real. All right, let's get into it. Excuse me, y'all. All right, so today we're going to start with chapter 1. And I have the first edition, so if you are following along with your own book and you have a different edition, there might be some differences. I'd be interested to know what they are, so please leave a comment. All right. And I would start with the preface, but I'll let y'all read that on your own if you would like. All right, chapter 1. So we're going to be covering the nature of law, ethics, and social responsibility of business. The chapter objectives are to define law, list and describe the functions of the law, list and describe the schools of jurisprudential thought, describe the law and economics theory of law, describe the critical legal studies theory of law, describe the flexibility of the law, list and describe the theories of ethical behavior, discuss business ethics, discuss the social responsibility of business. Chapter contents. What is law? Definition of law. Functions of the law. Schools of jurisprudential thought. Contemporary legal issue. Modern schools of jurisprudential thought. Flexibility of the law. Fairness of the law. Business ethics. Moral theories. International law. Ethical issues in international business, downing an aircraft manufacturer, the social responsibility of business, a matter of ethics, where there's smoke, there's... And by the way, I don't proclaim to be any type of expert. I'm here learning along with you all right? We have a quote at the top. The ultimate justification for the law is to be found and can only be found in moral considerations. Lord Macmillan, Law and Other Things, 1937. Every society makes and enforces laws that govern the conduct of the individuals, businesses, and other organizations that function within it. In the words of Judge Learned Hand, without law, we cannot live. Only with it can we ensure the future, which by right is ours. The best of men's hopes are enmeshed in its success. Businesses that are organized in the United States are subject to its laws. They are also subject to the laws of other countries in which they operate. In addition, business persons owe a duty to act ethically in the conduct of their affairs, and businesses owe a responsibility not to harm society. This chapter discusses the nature of law, business ethics, and the social responsibility of business. What is law? As mentioned, the law consists of rules that regulate the conduct of individuals, businesses, and other organizations within society. Laws are intended to protect persons and their property from unwanted interference from others. In other words, the law forbids persons from engaging in certain undesirable activities. When the desires of two or more persons conflict, the law must decide who has the paramount right. For some reason, that's reminding me of the scripture that says, "Where two or more are gathered in my name, there I am in the midst." The following excerpt from Justice Sedida's opinion in Kramer versus Kramer explains how the courts make this determination. Each person has a duty in society to avoid breaches of other persons' zones of personal freedom and power, which we refer to as their rights. A unique problem arises, however, in that bubbling cauldron of social interactions which we all call society. The problem arises when individual zones of freedom and power, rights, overlap. In these cases, the law must determine who had the superior right. A person whose lesser right is infringed by a superior right ordinarily has no claim for damages because the superior right creates a corresponding duty to observe that superior right. The person exercising the superior right has not acted beyond his or her zone of personal freedom and is therefore not liable for a breach of duty to another. Upon these basic principles, the law seeks to adjust rights and fairly compensate those whose rights have been breached by a failure to observe the duties imposed by life in society. The process or sorting out hierarchies of competing rights is many times a difficult and complex enterprise within the framework of our adversarial system. Definition of law. The concept of law is very broad. Although it is difficult to state a precise definition, Black's Law Dictionary gives one that is sufficient for this text. Law, in its generic sense, is a body of rules of action or conduct prescribed by controlling authority and having binding legal force. That which must be obeyed and followed by citizens subject to sanctions or legal consequences is a law. I'm going to read that one more time. Law, in its generic sense, is a body of rules of action or conduct prescribed by controlling authority and having binding legal force. That which must be obeyed and followed by citizens subject to sanctions or legal consequences is a law. Thus, the law includes constitutions, statutes, court decisions, administrative regulations, ordinances, and the like. Functions of the law. The law is often described by the functions it serves within a society. The primary functions served by the law in this country are 1. Keeping the peace, which includes making certain activities crimes. 2. Shaping moral standards, example, enacting laws that discourage drug and alcohol abuse. 3. Promoting social justice, enacting statutes that prohibit discrimination in employment. 4. Maintaining the status quo, passing laws Preventing the forceful overthrow of the government. 5. Facilitating orderly change. Example, passing statutes only after considerable study, debate, and public input. 6. Facilitating planning. Example, well-designed commercial laws allow businesses to plan their activities, allocate their productive resources, and assess the risks they take. Number 7, providing a basis for compromise. Approximately 90% of all lawsuits are settled prior to trial. Again, approximately 90% of all lawsuits are settled prior to trial. Now, keep in mind, this book was written in the 90s, I believe, so I'm sure that may, well, it may or may not have changed, but probably still in effect today is that a majority of lawsuits are settled. Number 8, maximizing individual freedom. Example, the rights of freedom of speech, religion, and association granted by the First Amendment of the U.S. Constitution. Number 8, again, maximizing individual freedom. Example, the rights of freedom of speech, religion, and association granted by the First Amendment of the U.S. Constitution. I'm going to pause for a second. All right, Amendment 1 says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. I'm sure we've all seen that violated many times through different marches. Schools of jurisprudential thought. The study of law is referred to as jurisprudence. There are several different philosophies about how the law developed. They range from the classical natural theory to modern theories of law in economics and critical legal studies. Legal philosophers can generally be grouped into the major categories discussed in the paragraphs that follow. So jurisprudence is the philosophy or science of law. The natural school. The natural school of jurisprudence postulates that the law is based on what is correct. Natural law philosophers emphasize a moral theory of law. That is, law should be based on morality and ethics. Natural law is discovered by humans through the use of reason and choosing between good and evil. Documents such as the United States Constitution, the Magna Carta, and the Charter of the United Nations reflect this theory. The historical school. The historical school of jurisprudence believes that the law is an aggregate of social traditions and customs that have developed over the centuries. It believes that changes in the norms of society will gradually be reflected in the law. To these legal philosophers, the law is an evolutionary process. Thus, historical legal scholars look to past legal decisions precedent to solve contemporary problems. The analytical school. The analytical school of jurisprudence maintains that the law is shaped by logic Analytical philosophers believe results are reached by applying principles of logic to the specific facts of the case. The emphasis is on the logic of the result rather than on how the result is reached. The sociological school of jurisprudence asserts that the law is a means of achieving and advancing certain sociological goals. The followers of this philosophy, who are known as realists, believe that the purpose of law is to shape social behavior. Sociological philosophers are unlikely to adhere to past law as precedent. The command school. The philosophers of the command school of jurisprudence believe that the law is a set of rules developed, communicated, and enforced by the ruling party. These philosophers assert that the law is not a reflection of the society's morality, history, These philosophers assert that the law is not a reflection of the society's morality, history, logic, or sociology. This school maintains that the law changes when the ruling class changes. All right, and then we have a contemporary legal issue. So let's see what that says. Modern schools of jurisprudential thought. Number 1, law and economics. Strange bedfellows or a perfect match. Should free market principles like the supply and demand and cost benefit theories determine the outcomes of lawsuits and legislation? Why that sound wrong to me? U.S. Court of Appeals Judge Richard Posner thinks so, and so do a growing number of other judges and legal theorists. These people are members of the Law and Economics School, or the Chicago School of Jurisprudence, which had its roots at the University of Chicago. According to the Law and Economics School, which is unofficially headed by Judge Posner, promoting market efficiency should be a central concern of legal decision making. In the area of antitrust law, for example, law and economic theorists would not find corporate mergers and takeovers to be illegal simply because they resulted in market domination. Instead, they would find this practice to be illegal only if it rendered the overall market less efficient. Focusing on cold